Hello and a very warm welcome to thorough newspaper analysis for 1st of April, which is brought to you by LawSikho. Now let's proceed with the agenda for today. At the very outset, we're going to have a look at some of the important national and international news updates. This is going to be followed by two legal news updates for today. And at the very end, we have an editorial to discuss, the title of which is Query on Prime Minister's Education, How the Case Moved from CIC to Gujarat High Court. This was published in the Indian Express. And with this, let's start with the TNF for today. So the first update is coming from the field of sports, and this is with respect to Shakib Al Hasan becoming the top T20 international wicket taker. He has surpassed him Saudi to become the leading wicket taker in T20 international cricket during the second T20 international match against Ireland, with 136 wickets in T20 international at an average of 20.67 and an economy rate of 6.8. Shakib is considered as one of the best all-rounders in T20 cricket.Moving on to the next update, which is from the national news segment now. हाल ही में बिहार गवर्नमेंट ने डिस्कवर किए हैं कुछ क्रिटिकल एंड इंपॉर्टेंट मिनरल्स इन नॉन फॉरेस्टेड एरियाज ऑफ द स्टेट. So pursuant to this discovery in several non-forest areas of the state of these minerals, the government of Bihar is making preparation for auction of mining rights with respect to these minerals, and the state government will engage SBI Capital Markets as the transaction advisor for the auctions and also to suggest terms and conditions based on which the auction would be held. In this respect, the Additional Chief Secretary and Mines Commissioner Harjot Kaur, she stated, and I quote, "Undoubtedly, the discovery of such critical minerals in non-forest areas of the state, it is a matter of great satisfaction. We don't have to seek permission from authorities concerned before initiating exploration activities, as these deposits, they are not in forest areas." Moving on to the next update, which is with respect to inauguration of Space System Design Labs in Ahmedabad. The Space System Designs Lab in Ahmedabad, it was inaugurated by ISRO chairperson or chairman S. Somnath. It is expected to boost the role of non-government entities in developing cutting-edge space technologies. It is equipped to design, analyze, and perform mission simulations for space systems. Now, the next update is with respect to Odisha Day Foundation Day. So, Utkal Divas or Odisha Day, it is celebrated every year on 1st of April. This day recognizes the separation of the state from the states of Bihar and the Odisha province on 1st of April in the year 1936. Now, the next update, it is with respect to conservation plan for conservation of Great Indian Bustard. The conservation of Great Indian Bustard, it has been identified as a priority under the central sponsored scheme Development of Wildlife Habitats, which provides financial and technical assistance to state and union territory governments for conservation efforts. Now we have come to the international segment for today. So the UAE, it has launched its national genome strategy, which aims to provide a comprehensive legislative and government framework to support the development and implementation of genomic programs. The program aims to collect 1 million samples nationwide and currently contains whole genome sequencing data from around 4 lakh citizens. Now with this, let's come to the legal update segment for today. हमारे पास दो updates है, एक तो बॉम्बे हाई कोर्ट से और एक है from the High Court of Jammu and Kashmir. So as far as the Bombay High Court update is concerned, this is indeed an interesting or a significant development. So the High Court of Bombay recently held that a transgender woman who has undergone sex reassignment surgery can be an aggrieved person under the Domestic Violence Act and has the right to seek interim maintenance in a domestic violence case. The court said that the term aggrieved person under Section 2A of the Protection of Women from Domestic Violence Act of 2005, it has to be given a broad interpretation, as the purpose of the act is to protect women from domestic violence. Now moving on to the next update, which is coming from the High Court of Jammu and Kashmir. So the Jammu and Kashmir and Ladakh High Court, it has recently ruled that inadvertence on the part of a party to produce a document before the court, it cannot be construed as a substantial cause within the meaning of Rule 27 of Order 41 of the CPC to allow application for production of additional documents. The name of this particular case is Mohammad Mukbul, Raghu and others versus Hilal Ahmed and others. And now we've come to the last segment for today's TNA, which is the editorial, the title of which is Query on PM's Education. देखिए, इस पूरे जो एडिटोरियल है उसका जो मुद्दा है या डिस्कशन का पॉइंट है वो ये है कि गुजरात यूनिवर्सिटी ने काफ़ी टाइम पहले गुजरात हाई कोर्ट में एक पेटिशन फाइल करी गई थी ये, और उस पर्टिकुलर पेटिशन में सेंट्रल इंफॉर्मेशन कमीशन का एक ऑर्डर को चैलेंज किया गया था। अब वो जो ऑर्डर है उसने यूनिवर्सिटी को ये डायरेक्शन दी गई थी दैट यू सर्च फॉर इंफॉर्मेशन अबाउट प्राइम मिनिस्टर नरेंद्र मोदी एजुकेशनल डिग्रीज। तो सेंट्रल इंफॉर्मेशन कमीशन ने ऑर्डर इशू किया या डायरेक्शन इशू करी गुजरात यूनिवर्सिटी को दैट यू लुक फॉर डिग्रीज issued in the name of Prime Minister Narendra Modi. And thereafter, Gujarat University approached the High Court challenging or impugning this particular order of the commission. And in response to that, the High Court of Gujarat has now allowed the petition. Now, this is the entire point of discussion. अब इस पूरे editorial को हम 4-5 segments में discuss करेंगे. पहला तो we're going to have an understanding of what was actually held by the High Court, and then we're going to look into detail as to what was the case before the High Court. हम थोड़ा सा इसका historical background देखेंगे, factual matrix इसकी discuss करेंगे, and then we're going to have a look at what were the arguments which were put forward by the council representing the University of Gujarat, and then इसके अलावा we're also going to have a discussion around a particular decision of the Delhi High Court also. And then we also have another case जिसका reference है इस editorial, which is a 2014 matter wherein also using the RTI Act itself एक applicant ने कोशिश करी थी दिल्ली यूनिवर्सिटी से प्राइम मिनिस्टर नरेंद्र मोदी के एजुकेशन बैकग्राउंड के रिस्पेक्ट में कोई इंफॉर्मेशन रिट्रीव करने की. So let's start with the editorial discussion for today. So see, Gujarat High Court on Friday allowed a petition by Gujarat University asking that a Central Information Commission order directing the universities to search for information about Prime Minister Narendra Modi's degrees, it be set aside. Now, Justice Biren Vaishnav of the High Court, he allowed this particular petition, and he also imposed a cost of rupees 25,000 on the Chief Minister of Delhi, Mr. Arvind Kejriwal, who had requested the information under the RTI Act and directed him to deposit the amount with the Gujarat State Legal Services Authority within a time-bound manner. Now let's understand the case before the High Court. See, the case originated from a hearing of Kejriwal's second appeal before the CIC in a case related to supply of information about his electoral photo identity card. In April of 2016, Kejriwal had submitted that he was ready to provide the required information about himself to the commission, but he added that the information with respect to Prime Minister's education, it also should be asked, and he should be asked to disclose the details of his education degrees. So essentially क्या हुआ था कि commission ने it was hearing second appeal, and which was filed by the Chief Minister of Delhi, and he stated that I am agreeing to furnish whatever information it is that is needed out of me, provided the same information or information with respect to education qualification of our Prime Minister is also sought. So with this particular update, what happened was the commission, the Central Information Commission, it decided to consider Kejriwal's response as an application under the RTI Act in his capacity as a citizen. तो जो Mr. Kejriwal ने ये कहा था कि you also go and seek information from Prime Minister Narendra Modi, तो उसके रिस्पेक्ट में मिस्टर केजरीवाल ने ये कहा कि आई एम रेडी टू फर्निश दिस प्रोवाइडेड यू ऑल्सो आस्क हिम टू फर्निश हिज इंफॉर्मेशन. तो देन ये जो सेंट्रल इंफॉर्मेशन कमीशन है, इन्होंने उसको एक आरटीआई के तहत एक एप्लीकेशन के तौर पर डीम कर लिया, and saying that Mr. Kejriwal, he is going to act as in his capacity as a citizen of India, and now he is seeking a certain piece of information, so we are going to deem it as an application under the RTI Act. So the Chief Information Commissioner, he also directed the Prime Minister's office to provide the specific number and year of Modi's undergraduate and postgraduate degrees from the University of Delhi and Gujarat University, so that it will be easy for them to search and provide any document related to it. This order underlined that not prescribing the educational degree-based qualification for contesting electoral offices, it is one of the great features of the Indian democracy, and what is needed is education, not degrees. However, when a citizen holding the position of chief ministership he wants to know the degree related information of the prime minister, then it will be proper to disclose the same. The commission directed the public information offices of both the Delhi University and that of Gujarat University to make best possible search for information regarding degrees in the name of Mr. Narendra Damodar Modi, in the year of 1978 for graduation from DU and 1983 for post graduation from Gujarat University, and provided to the appellant, who is Mr. Kejriwal, as soon as possible. Then thereafter, the University of Gujarat, it approached the Gujarat High Court against this particular order of the commission. Now let's understand कि गुजरात हाई कोर्ट की essentially contentions थी क्या. तो यूनिवर्सिटी ने ये सबमिट किया कि जो ऑर्डर है वो इसका कोई jurisdictional base है ही नहीं, and ये erroneous order है, and therefore it needs to be quashed. Senior advocate जो कि थे तुषार मेहता, who was representing the university, it stated that curiosity, it cannot be equated to public interest, and he emphasized that the university's plea must be allowed with costs, otherwise a great disservice will be done under the RTI Act, which is being used for settling scores. तो essentially उनका ये कहना था कि क्यूरियोसिटी ऑन पार्ट ऑफ अ चीफ मिनिस्टर वो एक ग्राउंड नहीं है कि वो ऐसा ग्राउंड नहीं है कि हम उसको मान ले कि दिस इज अ ग्राउंड ऑफ पब्लिक इंटरेस्ट, तो देयरफॉर वी कैन नॉट फर्निश इन्फॉर्मेशन. एंड उन्होंने ये भी फिर रिक्वेस्ट करी कोर्ट से कि आप इन पे कॉस्ट इम्पोज करिए, ताकि क्या है कि जो आरटीआई एक्ट है उसका पर्पस जो है वो सही चीज के लिए यूज हो, एंड इट सेट्स फॉर्थ एन एग्जाम्पल. Now, after arguments were completed, the High Court reserved its verdict on 9th of February and Friday, and then eventually Friday को गुजरात हाई कोर्ट ने इस petition को allow कर दिया. Now let's understand the Delhi University case. So see, 6 years before the Gujarat case, क्या हुआ था? Delhi High Court had set aside another order of the commission that had allowed an RTI activist to look at the BA results of Delhi University from the year 1978, which is the year जब प्राइम मिनिस्टर नरेंद्र मोदी ग्रेजुएट हुए थे दिल्ली यूनिवर्सिटी से. सो जनवरी में 2017 के जस्टिस संजीव सचदेवा of the Delhi High Court, he stayed the order of the commission, which was dated December 21, 2016, allowing RTI activist Neeraj Kumar to inspect the record of the results of all students who had passed the BA exam of DU in the year 1978. The High Court took note of DU's submissions and observed that information regarding personal information of third parties cannot be given out under the RTI Act. तो essentially दिल्ली हाई कोर्ट ने ये जो DU के काउंसिल ने आर्ग्यूमेंट्स करी थी उसको मद्देनजर रखते हुए ये कहा था कि कोई थर्ड पार्टी जो है किसी की पर्सनल इंफॉर्मेशन नहीं सीख कर सकते RTI Act के अंडर. It cannot be given out, and Delhi University had challenged the CIC order on the ground that it was arbitrary and it was capricious, and it also was untenable in law. The university, which was represented by then Additional Solicitor General Tushar Mehta, contended that inspection of the record cannot be allowed because details of roll number, father's name and marks obtained, ये जो है ये पर्सनल इन्फॉर्मेशन की कैटेगरी में आती है जो कि एक थर्ड पार्टी को हम रिलीज नहीं कर सकते. Mehta had told the court that universities hold the subject information in a fiduciary capacity, एक ट्रस्ट की कैपेसिटी में वो रखते हैं, and as such the same is an exempted information under section 8 clause E and J of the RTI Act. The bench also issued notice to RTI activist Neeraj Kumar. The plea was initially scheduled to be heard in April of 2017. However, वो मैटर अभी भी डिस्पोजल अवेट कर रही है, एंड नवंबर लास्ट ईयर में जस्टिस यशवंत वर्मा ही लिस्टेड द मैटर फॉर हियरिंग ऑन 3rd of May 2023. तो वी आर गोइंग टू हैव अ लुक एट हाउ द इवेंट्स अनफोल्ड देयर. अब हमारे पास एक 2014 का और सिमिलर डेवलपमेंट है, विच इज हंसराज जैन्स केस. तो इसमें क्या हुआ था, 2014 में एक और आरटीआई एक्टिविस्ट थे हु इज हंसराज जैन. ही सॉट डिटेल्स ऑफ स्टूडेंट्स हु हैड ग्रेजुएटेड इन 1978, सेम ईयर जब नरेंद्र मोदी ग्रेजुएट हुए थे, और उन्होंने ये कहा था कि आई वांट इन्फॉर्मेशन of all the students who graduated in 1978 with names starting with the letter N and M. Essentially, he was asking DU to reveal how many students by the name of Narendra Modi had passed their BA in the year 1978 as external students. डीयू के फिर जो सेंट्रल पब्लिक इंफॉर्मेशन ऑफिसर हैं उन्होंने इस रिक्वेस्ट को डिक्लाइन कर दिया, सेइंग दैट द इंफॉर्मेशन दैट वाज सॉट बाय द एप्लीकेंट इट वाज टू जनरल। एंड उन्होंने जो ये ऑफिसर थे सेंट्रल पब्लिक इंफॉर्मेशन ऑफिसर, उन्होंने कहा कि इट इज़ वेरी डिफिकल्ट टू सर्च सच नेम्स इफ रोल नंबर इज नॉट प्रोवाइडेड। एंड इसीलिए इस बार जो कमीशन है उन्होंने यूनिवर्सिटीज़ को डायरेक्ट किया था, एंड ऑल्सो द ऑफिस ऑफ पीएम की यूनिवर्सिटी उसको स्पेशली दैट यू गिव अस स्पेसिफिक डिटेल्स कि उनके नंबर क्या थे एंड एवरीथिंग, ताकि अगर द डिग्रीज आर टू बी सर्च so that would become easier. Now, Jain has appealed before the CIC, which closed this case after 6 months without making the information available. So this is with respect to the entire editorial. And with this, we have come to the end of the TNA for today. If you want to get access to the free study material that we provide, and also to the TNA slides which are used in this particular TNA, please join our Telegram channel using the link in the description, which is given in this video. And also you may scan the barcode here. If you want to get in touch with LawSikho with respect to anything, any query, kindly contact us using this phone number or this email address. And thank you for being with us.